well.
And don't consent to being called that name.
I understand, sir. All right, I do want to put on the record, I gave the parties this morning, it's an excerpt from a judicial bench book on opening statements. It's about a page and a half. I thought it would be helpful to provide to Mr. Brooks as he puts together his opening statement. It has reference to some Supreme Court rules, SCR, some case law, talks about the manner and purpose, scope, and other things. And as I indicated yesterday, sir, I like to call it the roadmap. It's referred to here as a framework so that the jury can better understand and evaluate evidence. It must also be based on the law and the evidence you believe is properly admissible. I'm going to further advise you at the time when you do make your opening statement that it not reference subject matter jurisdiction. That is, despite what I know you believe to be to the contrary, it is not a requirement to be proven in this case. It is not a factual or legal argument that is accurate, and therefore I'm prohibiting you from referencing that during either opening statements or closing arguments. With that, I believe
For the record, is this the what you're referring to? This
the page and a half is from my judicial bench book. I thought it would be helpful to you so that you have a better awareness and understanding of the manner and purpose of an opening statement. This is what guides me as I preside over cases.
okay? I accept for value in return for value these documents. I don't know why the reference to subject matter jurisdiction in the opening statement. I'm pretty aware that that wouldn't be part of an opening or closing statement. I don't.
Okay, great.
I don't get why that's
I wanted to make the
relevant.
record clear. So I appreciate you indicating to me that you're aware of that.
Even though subject matter jurisdiction has not been proven on the record and should
Sir,
be
it does
addressed.
not need to be proven on the record. It's established by law and by the fact that, as my written decision indicates, commenced when the criminal complaint was filed in this case. It's conferred by Constitution and by statute.
And who was the complaint filed by? Because subject matter jurisdiction has yet to be
I'm not going to go
proven on
down
the
this
record.
path today. I'm just advising you, you cannot reference that in your opening statement.
That was something I've already had the common sense to know, but also subject matter jurisdiction has not been proven for the record.
All right, next topic then. I believe the state has
Should be
filed a
proven for the
motion.
record by the prosecution.
The objection is
Alleged.
noted. It is not legally sound. It's overruled.
It's definitely legally sound.
All right,
Has yet to be
Attorney,
proven.
I'm going to turn to Attorney Opper. I believe they filed a motion this morning. Has it been pulled through? I probably just need to refresh, but Madam Clerk.
It was served on Mr. Brooks last night in the jail, Your Honor.
All right, go
I
ahead.
didn't-
You can make. Let me
I
just-
didn't look at the document. I accept for value, return for value the document. I didn't look at it. So I don't know what I'm supposed to say to that.
All right, well, Attorney Opper, it's your motion. I'll hear from you.
Your Honor, we are moving to amend the information with respect to one word in the entire document. We're asking to change the location of count 76. The information reads, as it reads right now, it reads at Frame Park. We're asking to change that to near Frame Park. We believe that that's a more consistent statement that aligns with the testimony of victim PPP, Erica Patterson, as she testified in this trial. We're not asking to change any criminal charges. We're not asking to change any dates. It's, I think, a very small change in the charging document. The defendant has been on notice of the facts of this transaction. It's reflected in a number of police reports and Ms. Patterson's recorded statement, which the defendant has copies of. And so I don't think that there's any grounds for a claim of prejudice by this change, and we're asking to move forward with that amendment to the information.
All right, thank you. Any position on that, sir?
Yes. First of all, for the record, there were originally 2 charges associated with this one party, and these charges have been charged for the better part of a year. I feel that if there was essentially one word that needed to be changed, it's been more than ample time for it to be changed. Even after one of the charges was dismissed, it could have been, that topic could have been visited at that time for it to change. I don't think changing one word at this point really has any bearing on the testimony or the actual charge. I don't understand why a motion needs to be heard about one word. Is think kind of at this point kind of a moot point. It's been charged like this for a year basically. The language hasn't ever been referenced to being changed before yesterday. So what is the significance of this now at this point?
Thank you, sir. Court is guided by section 971.29 sub 2 of the Wisconsin statutes, which provides at the trial, the court may allow amendment of the complaint, indictment, or information to conform to the proof where such amendment is not prejudicial to the defendant. Case law states that when an amendment to the charging document does not change the crime charged, and when the alleged offense is the same and the results from the same transaction, there is no prejudice to the defendant. State versus Wickstrom, 118 Wisconsin 2nd 339, found at page 348. It's a Court of Appeals case from 1984. And also, I point the parties to State versus Durango, 229 Wisconsin 2nd 1, and State versus Gerard, 189 Wisconsin 2nd 505. The first of those 2 cases is a Court of Appeals case from 1999, and then the second of those referenced is from the Supreme Court from 1995. I'd also point the parties to State versus Frey, 178 Wisconsin 2nd 729, a Court of Appeals case from 1993. As far as whether this is a moot issue or not, I'll find that it is ripe for determination by this court to hear this motion, and that is because the jury ultimately will be instructed similarly to what the jurors were instructed at the beginning of the case. The charges are read. Those are based off of the information, and this proposed amendment does conform to the proof. There is no prejudice to Mr. Brooks. It does not change the charge in any way. It is still the same offense. It's still from the same general information that was indicated in the criminal complaint. So for all of those reasons, I will grant the state's request to amend the information, and the state may file that document as soon as possible.
I have a question about that. So this same person is scheduled to testify again. What if something changes in the testimony?
I'm not going to answer that, sir. It would require me to speculate on what that situation might be and to give an advisory opinion, which I will not do.
But what happens if that happens?
I'm not going to answer that, sir. I can't. You're asking me to give an advisory decision. I'm not going to do that. I'm not allowed to do that, actually. Okay, so we've dealt with that then.
Makes no sense.
The state has not rested yet. Will the state anticipate calling any other witnesses?
Yes, Your Honor, as indicated yesterday, we do intend to recall Detective Casey to the stand, and I'd like to make a record in that regard, please.
Go ahead.
Your Honor, Detective Casey did testify once for the state early in the presentation of the matter. His focus at that point was largely on assisting the jury in understanding the layout of the parade route, giving background and contextual information to the jury on the different parade units that were impacted, what they looked like. We showed several videos with Detective Casey just for background and context purposes. He then went on to describe his personal interaction with the SUV as it came through the intersection of White Rock and Main. And essentially, that was the bulk of his testimony during his first testimony. We're seeking to recall him now. This is not unusual. It is commonly done in cases. We never excused him from his subpoena. We never asked for him to be excused from his subpoena. We always intended to recall him. We did this so that we can efficiently present the information to the jury. The types of questions we have for him now go more to the investigation itself and his role as the lead detective in this case. There will not be duplication or repetitive questions. I'm not going back to the corner of White Rock and Main with Detective Casey during this round of testimony. We want to ask him essentially about how some of the victims along the parade route were identified. We want to ask him about some of the topics that have been addressed throughout the course of the state's case as far as identification of the vehicle and identification of the driver. And we need to still introduce the certified bail forms from Milwaukee County for the 2 bail jumping counts. So he will be asked about that. I estimate my direct examination of Detective Casey would be about 20 minutes. So this is not going to be repetitive. It's information, again, that he has as the lead detective in the case to assist the jury in understanding some of the things on the back end that he was involved in, not his role at the parade. So we have been very efficient in our presentation. I believe Your Honor would agree with that. We're not wasting time here, but we just have a few more questions to wrap this up.
All right, any position from you, sir?
And yes, I do. And I'm gonna start with what was just said. The prosecution feels that they've been efficient in their presentation. So it seems like to me an attempt to get more questions in that could have been asked in the first place. If Your Honor recalls, Detective Casey was testifying for quite some time, to the point that we actually had to have a break before I can cross-examine Detective Casey, if you recall. He was up there quite some time. That was more than enough time for any other foundations to be laid, any questions to be asked at that time. And also, from my recollection, he was asked to be excused. So essentially having him start off and then end it, I feel like it's an attempt to get questions that was maybe forgotten to be asked, answered. And essentially what more could be gained by a second testimony from Detective Casey? What more can be gained that hasn't already been learned? We learned about vehicles and identification by numerous witnesses. We've been through the inspection of the vehicle. We've been through DNA analysis of the vehicle. We've been through numerous things in regards to the vehicle. Even the reconstruction testimony. We've been through all of that. Seems like nothing more than to get extra questions answered that could have been asked from the get-go. As seeing as how he was up there for quite some time and none of those issues were raised at that time. What would be the significance at this point? When it's essentially I should be already presenting my defense at this point in trial. I don't see the relevancy of it, and to my knowledge, he was excused from his subpoena. So,
Thank you,
what's the
sir.
relevancy?
Thank you, sir. The court has discretion under 90611. It's a statute I've quoted with frequency during the course of these proceedings. I've listened to the state's offer of proof. I've listened to the objections made by the defendant. In my discretion, I am going to allow Detective Casey to be recalled for the reasons laid out by the state. As I understand his proposed testimony today, it is not to rehash topics that he was questioned about initially. This has to do with his investigation and role subsequent to the initial contact with Mr. Brooks at the beginning of the parade route. And as the state indicated, we'll address certain things, including identification related to the vehicle, of the driver throughout the investigation, identification of certain victims. In addition, there are 2 additional charges for which the state has not yet presented testimony, so it's proper for those as well. It's relevant, and I will allow it for those reasons. So the state will be able to recall Detective Casey, and we'll have that done, obviously, when the jury is brought out. Any other preliminary issues then from the state?
Your Honor, just I am working on going through our list of exhibits, and I will work with your clerk to make sure that everything that I'm showing was admitted and accepted by the court is what she has, so that we can clear that up before we actually rest.
All right, thank you. Anything preliminary from you, sir?
Yeah, just a quick question about the last thing again. I will be able to re-cross-examine.
Oh, yes, you will.
And is essentially anything left off limits to my cross? Or what?
I may limit, depending on where we go, if the questions deal with what he testified to previously. It's primarily to cross-examine based on the new testimony. However, 90611 also says this: a witness may be cross-examined on any matter relevant to any issue in the case, including credibility. It does say in the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct. So I'll give you some leeway, and I'll trust the state will make appropriate objections, and I'll rule on them if and when they're made.
Because I'm not intending to go too much back into the previous testimony, but I think it made a few points from the earlier testimony
I
may
think
come
that's
into
fair.
play, and I just wanted to make sure
I think that's fair.
that wouldn't be a problem.
I think that's fair, sir.
Also, really quick, I did look over some information provided by the prosecution as far as the pretrial offer that I did not have knowledge of until, I don't know if that was today, Thursday. I don't know if that was Monday or Friday or Monday, one of those days. I've put together, started to, I won't say it's completed, that wouldn't be fair to say. I've put together, or started to put together a counter offer, so I just wanted to advise the court that I was putting that together.
All right, thank you, sir. If and when you do provide that to the state, please let me know so we can make a record of that. All right, anything else? If not, then we'll have the jury brought out.
We do have one last large map here, Your Honor, that I'm going to ask to put up and face backwards like we did the other day.
All right, go ahead since the jury's not here.
Got it. Sure. Thank you. All rise.
Thank you, everyone. Please be seated, and good morning, ladies and gentlemen of the jury. I know it's a little chilly in here. I'm not sure if that will change now that we're all in here. If at any time that temperature is too cold for you, let me know, and we can have that adjusted. All right, Attorney Opper, you may call your next witness.
Thank you, Your Honor. The state would recall Detective Tom Casey.
Good morning, Detective Casey. Please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat. Please state your first and last names for the record.
Thomas Casey.
Thank you. Go ahead, Attorney Opper.
Thank you. Detective Casey, I'd like to begin by asking you to refer to the item behind you. There's a large poster board there. If you could please place that on the easel and identify the exhibit number for the court.
It's exhibit number 15.
Thank you. And we've had testimony about this exhibit throughout the trial. Is that right, sir?
Yes, we have.
All right. Your role in this case was what, sir?
Objection, leading.
Overruled.
Initially, I was on traffic control for the parade. Shortly after the incident happened, I was assigned as lead detective for the case.
Were you the individual who created this map, State's Exhibit number 15?
Yes, I did.
Okay. And I would like you to talk a little bit about how victims were identified in this case.
Objection, leading.
Overruled. Foundational. The witness may answer.
So at least initially, can you tell us, like, in the day or two after the parade, what happened?
Objection, leading.
Overruled. You may answer.
So initially, that night, we knew that the victims were taken to different hospitals around the area, generally 5 different hospitals. So at the beginning, we began by having detectives assigned to each hospital. Waukesha Memorial Hospital received the most patients, so they also had a lieutenant that was assigned there as a team leader. As the patients came in, they were identified by detectives. The hospitals also provided us with lists of patients that they had, and we went through those lists and tried to identify people that came in and were being treated.
And then eventually, were there follow-up interviews conducted with these individuals?
Yes, there were.
What if the individual was a person under the age of 18?
Objection leading.
Overruled, you may answer.
If the person was a minor under 18, then we would reach out to their parents, talk to the parents. Some of the kids were able to talk to us, but we got the majority of their statement from their parents.
Okay. And do you believe that the names on Exhibit 15 truly reflect all the injured victims that you were able to identify in the course of this investigation, sir?
Objection speculative.
No, I do not.
Hold on, there's been an objection. It's overruled, and the witness will repeat his answer.
No, I do not.
Can you explain that?
Objection leading.
Overruled.
Just because of the scope of the investigation, we had so many people that were hurt, we had to come up with some kind of parameters to limit the people that we would call victims. One of those parameters is that they had to receive treatment at a hospital. Another one is that they had to be in the street when their injuries occurred. So there are some people that were injured, maybe on the sidewalk, trampled by the crowd, or received injuries that they didn't get hospital care from. You know, and unfortunately I learned later on there was even a person that was in the band that somehow we missed her being reported that she received a broken leg. So there are some that are not on the map, but all the people that have been charged are on the map.
So you mentioned people on the sidewalk. We did have some spectators testify in the trial, correct?
Objection leading.
Overruled, foundational.
Correct, but they were more in the roadway or on the curb, not on the sidewalk, or not running away from the incident when it happened.
I see. So was, in your mind, when you were leading this investigation, trying to identify victims, what was the importance of the SUV in the injuries that were caused?
Objection leading.
Sustained as to the form of the question, please rephrase.
Why were the spectators that are on this map included?
Because they were directly contacted by the SUV that came down the street.
If a person were injured because they were trampled by the crowd, are they on this map?
We
Objection
exclude those.
speculative.
Overruled, the detective may answer.
Those people were excluded from the map.
There were some people like that, right?
Yes, there
Objection
were.
leading.
Okay.
Please make
Sorry.
sure.
I
Thank
know.
you. I'll allow his answer to stand. Next question.
All right. I'd like to put up for you exhibit number 32, which has been previously identified. I'm sorry, admitted.
I'm sorry, you said 32?
Yes.
You said
Yes.
32? Okay, thank you. Sorry, I just missed it. Just to the witness or published, because it's been received.
Yes, we are going to publish this, Your Honor.
Go ahead.
But
Permission granted.
Okay, thank you. And while we're waiting for it to come up in the jury box,
I don't have it on my screen.
It may take a second. Hold on. If it's not, let's check the cables.
We don't have it
Yeah.
either.
I can see it. The witness can see it. Go out it. Thank you for letting us know, sir.
just the front tables, back tables on, Your Honor.
Hold on. I'm going to stop source for a second. I know. Anything? Yeah? You can see it on the screen though, right, sir? On the, there's screen, obviously, on the far side of the courtroom and then to your right.
It's always better on here because
I understand. We'll get our tech guy over here to look at it, but it's previously been received and we can see it on the two other monitors. So for now, we're going to continue. If there's anything new, I'll make sure to pause. Go ahead.
Detective Casey, I want to focus your attention specifically as to the extreme dance team. We heard testimony about several of the girls on the team being struck and injured. Do you remember that testimony, sir?
Yes, I do.
Overruled, it's foundational. The answer may stand.
Do you know if there were other people associated with the extreme dance team that were injured?
Objection, speculative.
Overruled, he may answer.
Yes, I do.
And do you know the names of these people?
Objection, hearsay.
Overruled, he may answer.
Yes, I do.
What were their names, please?
Kathleen Pellmeyer,
Speculation.
Overruled, he may answer.
Go ahead, sir.
Kathleen Pellmeyer, Jennifer Stover, and Mitchell Lampine.
What was their role with the dance team?
Go ahead.
Jennifer and Kathleen were support people. Jennifer's daughter was marching the parade. And then Mitchell was there to hand out candy with his stepmom.
Okay. I'm going to now play, it's still not being displayed on our tables, Your Honor, but it is displayed on the two large monitors in the courtroom. So do I have permission to proceed?
Which exhibit?
This is 32.
Oh, yes. If we get to a new one that hasn't previously been received, then
Yes,
I will
okay.
pause to get
All
the
right.
tech people in.
All right. And
Go ahead.
Objection
Bailiff.
as to relevancy.
Overruled.
The bailiff confirmed it's on in the jury box, Your Honor.
Thank you.
All right, please play. From the 32-second mark, I'm sorry, 35-second mark to 47 seconds.
How long is the exhibit?
Looks like it's a minute 23 according to what I can see on my monitor.
Definitely.
It is 123 total. We're only playing this 12-second clip from 35 to 47.
Thank you.
And please pause. Do you see any of the individuals you were just testifying about enter the screen, sir?
Objection, speculative.
Overruled, he may answer.
Yes, I do.
Could you identify them by using the touch screen?
Objection, leading.
Overruled, he may answer.
I'm going to draw one big circle.
Okay?
It has two individuals. It has Jennifer and Kathleen. Kathleen has the red jacket on, and directly to her left would be Jennifer in a black jacket.
Okay. A little hard to see right now, but as
Yeah,
they
it's very hard to see.
as they
Keep
walk,
going.
could you see two people walking there, sir?
Yes, ma'am.
Okay. Please clear the screen and continue playing. And pause. And I'm sorry, because I can't see the counter, Your Honor.
It is at 44 seconds.
44 seconds, thank you. Paused at 44. Do you see anybody else that you just testified to in the video at this point, sir?
Objection, speculation.
Overruled, he may answer.
Yes, I do.
And who is that?
Leading.
Mitchell.
Objection.
Overruled.
Mitchell Lampine.
Please circle Mitchell. Do you know Mitchell's approximate age?
Objection, speculative.
Overruled.
I believe he's about 10.
Okay. All right, we can take down 32. Did, this video goes on to show the red SUV drive through the extreme dance team, correct?
Objection, leading.
It's foundational. Your Honor.
Overruled, it's foundational, it's previously been received. Go ahead.
Yes, it does.
To your knowledge of this video, sir, did those individuals, Mitchell and Ms. Stover and Ms. Pellmeyer, remain along the left side of the road there as the SUV went through?
Objection, leading.
Overruled, the witness may answer.
They were hit by the vehicle and then moved to the left.
Let's take a pause for a second. We
Yes.
have our IT experts. Hopefully they can get this figured out.
A lot of pressure.
Go ahead.
Could you put something on the screen that's okay with you for the moment?
Next one will be 132 if you want to. No, I'm sorry, 55.
It's on our screen.
It's on now.
Hold
got
on,
it.
let's make sure. Do you have it now, sir? Yes?
Yes.
Oh, good, great. It's on mine, it's on the witness.
Do they have it too?
All right.
Just
Thank
like
you.
real life. You call the help desk and they show up and now it works, yeah.
Jury monitors, we're working. It's not, hold on, let's make sure. It was just working. There's a delay.
Well, maybe next time I'll just take those down and the whole, take it down and put the whole thing back on.
Are they still off?
Yeah. Sometimes they take like.
It can take 30 seconds.
What exhibit is this one?
This is 55.
All right, it's on. Very good. We're up and working. And 55's previously been received, so go ahead.
All right.
Objection to the relevancy of 55.
Noted, overruled. Go ahead, Attorney Opper.
Detective Casey, Exhibit 55, can you see at the end of the road there, or the top of the screen, what unit is involved in Exhibit 55, please?
Yes.
Please tell us.
Objection leading.
Overruled.
It is the dancing grannies that are approaching from the right.
Okay. And one of the dancers, we have her testimony that was involved with the grannies was a woman by the name of Lola Hospital. Is that correct?
Objection leading.
Overruled. It's foundational. The witness may answer.
Yes, she was.
Is there video showing Miss Hospital being struck by the SUV?
Objection leading.
Sustained as to the form of the question. Please rephrase.
Sure. Is the exhibit, you've seen Exhibit 55 before?
Yes, I have.
Are you able to identify Miss Hospital, Lola Hospital in Exhibit 55, sir?
Objection leading.
Overruled.
Yes, I am.
All right. We're going to play the clip, Your Honor, from from 4 seconds to 8 seconds at 50% speed, and it is zoomed in on the middle of the road where the dancing grannies are located.
All right, go ahead. Thank you.
Please describe for the jury what you just saw in the video, sir.
Objection leading.
Overruled.
I saw the red SUV driving westbound on Main Street, approaching the dancing grannies and hitting Lola Hospital and then striking 2 other dancing grannies.
When you say hitting Lola Hospital, what did you see?
Objection leading.
Overruled. You may answer.
I saw the left side of the car come in contact with her, and then her body moved to her left after.
Did Miss Hospital report any injuries to the Waukesha Police Department?
Objection leading.
Overruled. The witness may answer.
Yes, she did.
All right, sir. I'd like to now ask that Exhibit 118 be published for the jury. This has previously been admitted.
Permission granted.
Objection to the relevancy of 118.
It's previously been received. Go ahead.
Sir, do you recognize the item shown in Exhibit 118?
Yes, I do.
And in addition to the photograph, have you had an opportunity to examine that item or items
Objection leading.
personally?
Overruled. The witness may answer.
Yes, I have.
And Mr. Johnson from the crime lab testified about these items yesterday, but I'd like you to tell the jury what you remember of these items, please.
Objection leading. The form of the first part of the question.
Overruled, the witness may answer.
So this is the red SUV that was used in the parade attack. This is a picture of it taken after. I remember a hood from a white jacket and a hat, a black hat with snowflakes on it, being pressed in between the hood and the windshield wiper of the vehicle.
Objection to it being called an attack. I think that's a disparaging remark for the record.
Your objection is noted, and the answer will stand. I will instruct the witness to simply describe what he is seeing without further characterizing it, as it will be up to the jury to determine the facts in this case. Go ahead.
Thank you. When you saw these items on the hood of the red SUV, did you later come to recognize where they may have come from?
Objection, leading.
Overruled, the witness may answer.
Yes, I did.
What did you determine?
I determined that they were the jacket, hood, and hat that Virginia Sorensen was wearing while she was walking in the parade.
I'd like to display to the witness only, please, Exhibit 177. This has not yet been received, Your Honor.
All right, go ahead, please.
Is 177 on your screen, sir?
Yes, it is.
And what do you see in Exhibit 177?
Objection, leading.
Overruled.
I see two dancing grannies carrying a Milwaukee Dancing Granny sign, and the woman on the left is Virginia Sorensen, and she's wearing a black hat with snowflakes, wearing a white jacket with a hood on it.
Move to admit 177 and permission to publish, Your Honor.
Objection to the relevancy.
The objection is overruled. Exhibit 177 is received. Permission to publish is granted.
Said 177?
177, yes. Go ahead. And if the jurors would let me know when it's in the jury box as well, please. All right, thank you, it's there.
And again, just so we're clear on the record, please circle Virginia Sorensen and the hat in this picture.
Objection, leading.
Overruled.
That is Virginia, and then this would be the hat and hood that I believe was found on the SUV.
Okay. Detective Casey, there were many videos that have been shown to this jury, correct?
Objection, leading.
It's foundational, Your Honor.
Overruled, the witness may answer.
Yes, there have been.
To your knowledge, are there any videos that display the license plate of the red SUV as it goes along the parade route?
Objection, leading.
Overruled.
Yes, there are.
Is it possible to capture a screenshot from those videos to see the license plate of the red SUV along the parade route?
Yes, there are.
I'd like to display for the witness only, Exhibit 150.
Go ahead.
Is 150 on your screen, Detective?
Not yet.
Okay,
It is now.
all right. Do you see Exhibit 150?
Yes, I do.
Please describe what you see in Exhibit 150.
Objection, leading.
Overruled.
I see the red SUV that was driven through the parade route, and it's at the time when it was contacting the Waukesha South band members. In that photo, you can read the license plate number.
Do you believe this photo is a true and accurate representation of the events of the day?
Yes, I do.
Move to admit 150 and permission to publish.
Objection. How does this go to investigation?
Um,
Exhibits
Overruled.
on investigation.
Exhibit 150 is received. Permission to publish is granted.
The image is a little blurry, correct?
A tad.
Can you please point out the license plates in the photo and read it for the jury?
Is it okay if I circle it?
Yes.
Overruled. You may do so.
That is the license plate number, and I read ADP 9256.
All right. Now I'd like to show to the witness only, number 151, please.
Go ahead.
Please describe 151. Oh, please clear the screen, Madam Clerk.
This photo is of the red SUV on the parade route. It's just photo taken just prior to the Barris Logistics float, and the band director is in the lower left-hand side of the video. It shows the red SUV with the license plate number displayed.
Do you believe this photo represents a true and accurate depiction of the events of the day?
Yes, I do.
Move to admit 151 and permission to publish, Your Honor.
Objection to relevancy.
Exhibit 151 is received. Permission to publish granted. The objections noted and overruled.
I recall this state saying they had 140 exhibits. How did we get this many?
Keep going, Attorney Upper.
Detective, please describe what you see in 151. I think you did describe it. Strike that. Please circle the license plate and read it for the jury.
Objection leading.
Overruled.
ADP 9256.
Thank you. It's still not up. Okay, I'm sorry. Gotta wait for the jury.
Go ahead.
Detective Casey, during your investigation, did you uncover any other videos linking Mr. Brooks to this same vehicle with this same license plate?
Objection. I don't consent to being called their name and it's leading the witness.
Overruled as to both counts. You may answer.
Yes, we have.
Could you describe this video for us, please?
Objection leading.
Overruled.
There's a video that we obtained from social media that shows Mr. Brooks standing next to the SUV, and you can clearly see the license plate number on the vehicle. I believe the video was taken sometime prior to November 21st, 2021.
Okay, I'd like to display for the witness only Exhibit 175, please.
Go ahead.
Please identify 175.
This is
Objection. Relevancy.
Overruled. You may answer.
This is a photo. There's two individuals in the photo. The individual on the left, I know to be the person referred to as Daryl Brooks. It displays a vehicle, a red Ford, and it has the license plate number, which is displayed in the photo.
What is the source of this photo?
Objection leading.
Overruled. The witness may answer.
We obtained it through social media.
Okay. I mean, this is a photo versus a video.
This is the photo taken from
Hold
a
on.
video.
I understand the objection. It's sustained. It's foundational. This particular question, the witness may answer. Go ahead.
This is
Overruled
a
or sustain.
Overruled.
You said substantial.
What did I say?
Yes, you did.
Sorry. I meant it's overruled. The witness may answer. Sorry, I'm taking notes. I was writing the word source, and I think that's why I did that. In any event, go ahead and answer. Sorry about that, for any confusion I may have caused.
This is a screenshot taken from a video.
Move to admit 175 and permission to publish, Your Honor.
Objection to that. What's the relevancy? I don't see the alleged defendant in here.
Your objection is noted. It is overruled, and Exhibit 175 is received. Permission to publish is granted.
Where's, oh, sorry.
The jury would also let me know when it's in the jury box monitors, or on the jury box monitors. All right, go ahead.
Detective Casey, is person you know as Daryl Brooks in this photograph?
Objection, I'll consent to being called that name and leading the witness.
Overruled. The witness may answer.
Yes, he is.
Please circle or X or mark in some fashion. How do you know that's Daryl Brooks there? His back is to us.
Objection, leading.
Overruled.
I've watched the video in its entirety and I've seen his face in the video.
Okay, that can go down, please. Detective Casey, in total, how many videos do you think were collected by the Waukesha Police Department during this investigation?
Objection, speculative.
Overruled. He may answer.
We have at least 65 to 75 files. Some of those files contain multiple videos, photos, could be 10 each, so I would say probably 300 to 400 videos we have collected.
What were the source of those videos?
Some of the videos came from different people that were at the parade. Some of them are from city-owned cameras, and some of them are from fixed surveillance systems from businesses that were in downtown Waukesha.
Were all of the videos that were available shown to this jury?
No, they were not.
Objection, leading.
Overruled. He may answer.
No, they were not.
Have you personally observed and reviewed each of the video files available in this case, sir?
Objection, speculative.
Overruled. He may answer.
Yes, I have.
To your knowledge, sir, did any video ever show a different person behind the driver's wheel of that red SUV?
Objection, leading.
Overruled. The witness may answer.
I have never seen anyone driving the vehicle besides the defendant in any of the videos that I looked at.
In any of the videos, were you ever able to see multiple people inside the vehicle?
Objection, speculative.
Overruled. The witness may answer.
None of the videos that we have looked at showed anyone else in the vehicle.
Do any of the videos at any point show the red SUV coming to a stop, a complete stop along the parade route?
Objection, leading and
Oh.
speculative.
Overruled. The witness may answer.
I've never seen a video that shows the vehicle slowing or stopping while it was on the parade route.
Do any of the videos show the driver of the vehicle exit the vehicle to check on a person who had just been struck by the vehicle?
Objection, leading.
Overruled. The witness may answer.
I never observed in the videos the driver of the vehicle to stop and check or exit the vehicle on anyone.
There was testimony earlier in this case about witnesses observing multiple people running from the car. Do you remember that?
Objection, leading.
Overruled. The witness may answer.
Yes, I remember that.
Were there multiple reports like that, sir?
Initially, there were some reports like that.
When the vehicle was found on Maple Street, you weren't there.
Correct.
Objection, leading.
Overruled. His answer may stand.
Do you know what police activity occurred when the vehicle was found on Maple?
Objection, speculative. He just stated he wasn't there.
Overruled. The witness may answer. He was asked, what does he know?
Yes, I do.
Please tell the jury what happened when the SUV was found on Maple.
Objection, leading.
Overruled. The witness may answer.
Initially, Officer Moss went, he secured the vehicle, did not find anybody in the vehicle. There was an initial report that saw some other people running from the area of the vehicle. After that information was given back to us, we sent detectives down to the area to investigate further to see if we could corroborate and find out if that was true or not.
After that investigation, did you have other suspects or just one person?
Objection, leading.
Overruled. The witness may answer.
Based on the information of what everybody saw on the parade route, and then the detectives that went back down to Maple Avenue and interviewed the people that reported the people running, our investigation determined that there was only one person in the vehicle and there was no other suspects that we were looking for.
At some point in your investigation, Detective Casey, were you given a Ford key?
Objection, leading.
Overruled. The witness may answer.
Yes, I was.
What was your understanding as to the source of that key?
My understanding that key was taken from Mr. Brooks when he was taken into custody and turned over to Detective Stern and Detective Carpenter.
Objection, I don't consent to being called that name for the record.
Noted. Overruled.
How did you get it?
Objection, leading.
Overruled. The witness may answer.
He just stated how he got it.
Overruled. He may answer.
Detective Stern brought me the key the morning after the incident.
Did you do anything with the key?
Yes, I did.
Tell the jury what you did, please.
Objection, leading.
Overruled.
At that point, the vehicle was at the Waukesha County Sheriff's Department Secure Storage Facility. Mr. Johnson was over there processing the vehicle. I went there and I took the key with me and I checked the vehicle to see if the key would work in the car.
What did you find?
Objection, leading.
Overruled.
I found that the key worked the door locks to unlock the car. I also put the key in the ignition and it turned the ignition lock.
Thank you. Detective Casey, you've heard testimony about the manner in which the defendant was identified by the name of Daryl Brooks. Do you recall that testimony, sir?
Objection, I don't consent to being called that name. He's leading the witness.
Overruled. Foundational. The witness may answer.
Yes, I do.
Did you endeavor to verify the identification of the subject you had arrested for this incident?
Objection, leading.
Overruled.
Yes, I have.
Did you verify his identity by the name of Daryl Brooks?
Objection, I don't consent to being called that name. Leading.
Overruled. The witness may answer.
Yes, I have.
How did you do that?
Objection, leading.
Overruled.
There were a couple different ways. One way is when a person is taken into custody, we take their fingerprints. We check that against other records that are kept by the state. Those fingerprints matched Daryl Brooks. I've also spoken to 3 women that he has children with. They verify that is his name that he has always gone by. I have also spoken to his mother, which states that that's the name that he has gone by always.
I'd like to put on the screen for the witness only Exhibit 88.
Go ahead.
Do you see Exhibit 88, sir?
Yes, I do.
Objection to this, what's the relevancy?
Overruled. Go
Can you-
ahead.
Grounds for the overrule?
Relevant.
In what way is it relevant?
Two of the counts alleged in this case. Go ahead.
Can you please identify Exhibit 88, sir?
This is a bail bond through Milwaukee County Circuit Court for Daryl Edward Brooks, the date of birth of 2/21/82.
To your knowledge, was Mr. Brooks on bail through a Milwaukee County case on the date of November 21, 2021?
Objection leading.
Overruled. The witness may answer.
Yes, he was.
And what is the date of this bail form, please? I believe it's near the bottom.
The date on the bottom
Objection
is
leading.
Overruled. The witness may answer.
2/21 of 2021.
Was Mr., we'll strike that. By classification, can you tell us the level of charges that Mr. Brooks was pending on for this bail?
Objection. You've already made a ruling on it.
Overruled. The witness may answer.
All the charges that I see in here are felonies.
To your knowledge, was this bail in full force and effect on November 21 of 2021, sir?
Objection.
Overruled. You may answer.
Yes, it was.
And in the middle of the form, do you see the conditions of bail that were set upon Mr. Brooks?
Objection leading.
Overruled.
Yes, I do.
And I'm looking under paragraph B, the third bullet. Do you see that?
Yes, I do.
Could you please read that bail condition to the jury?
Objection leading.
Overruled. The witness may answer.
The state defendant shall not commit any crime.
Thank you. Move to admit number 88, Your Honor.
Objection.
Exhibit 88 is received.
I'd like to display for
It was
the...
already speculated to. How's that coming into evidence?
Overruled. And permission to publish.
I'm sorry, I did not seek to publish this, Your
Oh,
Honor.
all right. Turn that
I
on.
request a legal finding of fact for that.
The objection is noted. It's overruled. Continue. Attorney Opper.
Thank you. I'd like to display for the witness only Exhibit 89.
Go ahead.
Sir, can you please identify 89?
Objection.
Overruled.
Relevancy.
Overruled.
This is
This has been speculated, stipulated to as well. How's it evidence? How's it being admitted?
The objection's noted. It's overruled. The witness may answer.
I request a legal finding of fact for that too, Your Honor.
Noted. Overruled. Go ahead.
This is a bail bond through Milwaukee County Circuit Court for Daryl Edward Brooks with the date of birth of 2/21 of 1982.
Is this a different case than what was displayed in Exhibit 88?
Objection leading.
Overruled.
Yes, it is.
Are you able to make any observations about the level of charges related to this case, sir?
Objection leading.
Overruled.
It appears that there's 4 charges, 2 of which are felonies.
Okay. And on the bottom of the form, can you tell the date that this bail was issued?
Objection leading.
Overruled.
States 11/11 of 2021.
The, directing your attention again to that same location in the middle of the page under paragraph B, the third bullet. Could you please read the conditions of release that were set by the court in that case?
Objection leading.
Overruled. The witness may answer.
Defendant shall not commit any crime.
To your knowledge, sir, was this bail in full force and effect on November 21 of 21?
Objection speculative and leading.
Overruled as to both. The witness may answer.
Yes, it was.
Finally, sir, I'd like to put up one last item for you, or two items. 1 second, please. I'd like to display for the witness only Exhibit 13.
Objection, what's the relevancy of this? How does it say any foundation to testimony?
I'll give the state some leeway to establish that. Go ahead.
Thank you. Sir, do you recognize can you tell if Exhibit 13 is a video, sir?
Yes, it is.
Okay. Have you seen this video before, sir?
Objection leading.
Overruled.
Still relevancy. Where's the relevancy?
The state is asking the foundational questions. The objection's a bit premature. I'll take it under advisement. Go ahead, Attorney Opper.
Yes, I have.
What does this video depict?
Objection leading.
Overruled. The witness may answer.
Objection speculative.
Overruled. Go ahead.
This video depicts the backyard at 4014 North 19th Street in the city of Milwaukee. That's the address of Dawn Woods, the mother of Daryl Brooks. And on the lower left-hand corner, you can see a Ford Escape.
In the lower
Objection.
right.
I move to strike that. How does he know? What?
The objection's noted. Overruled. You can ask him on cross-examination. You can question him about that. Go ahead.
In the bottom right-hand corner of the exhibit, do you see a date and time stamp for this video, sir?
Objection leading.
Overruled.
Yes, I do.
What does it say?
It says 11/21-2021, and then it says 13:26:18.
What do those numbers represent, sir?
Objection leading.
Overruled.
To me, it means that the video was taken on November 21st, 2021 at 1:26 p.m.
And do you believe this video is a true and accurate representation of the events of that afternoon at that location, sir?
Objection speculative.
Sustained. If you could lay a little more foundation,
Sure.
please.
How did you come into possession of this video, sir?
The defendant's mother provided it to us.
And do you know approximately when it was obtained?
Objection speculative.
Overruled.
The evening of November 21st, 2021.
Do you know if the defendant's mother was cooperative with police in providing the video?
Objection relevancy.
Overruled. The witness may answer.
Yes, she was.
Do you know if the video was provided to police when asked?
Objection leading.
Overruled.
Yes, it was.
Do you have any reason to believe that the video was altered or modified in any way before it was provided to police?
I do not.
Move to admit 13, Your Honor, and permission to publish.
Objection. Where's the relevancy?
Noted. Overruled. Exhibit 13 is received. Permission to publish is granted.
For the record, this is a video. It's 49 seconds in duration. We're going to play it in full. There is no audio, and it will be played at normal speed. Oh, hang on, don't play yet.
Yes, if the jurors would let me know when the monitors are displaying the video. All right, go ahead.
Detective Casey, were you able to see any emblem on the front grille of that vehicle as it drove away?
I would have to look at it again.
Okay, I'm sorry. Let me ask you this. Did you see any damage to the front end of that vehicle as it drove away?
Objection leading.
Overruled.
I did not.
Okay. I'm going to put up State's Exhibit 14 now, please.
Go ahead. Just to the,
Yeah, just to the witness only, please.
thank you.
Do you recognize Exhibit 14, sir?
Yes, I do.
What is the source of Exhibit 14?
This is a still shot taken from the video.
The same video we just saw, number 13.
Yes.
Okay. Move to admit 14 and permission to publish, Your Honor.
Objection relevancy.
The objection's overruled. Exhibit 14 is received. Permission to publish is granted.
Sir, do you see Daryl Brooks in this photograph?
Objection. I don't consent to being called that name again for the record.
Noted. Overruled.
Yes, I do.
Can you identify or, excuse me, describe the clothing items that you see him wearing in this photograph? Oh, it's not in the jury box yet, I'm sorry.
You can state your objection, though.
Leading.
Overruled. The witness may answer.
Mr. Brooks is wearing a red t-shirt, blue jeans, and he has blue-colored flip-flops on with white socks.
And what's the date and time stamp for this photograph, please?
It's 11/21/2021 at 13:26:08 hours.
And that's what time, sir?
Objection leading.
On the 12-hour clock.
Objection leading.
Overruled.
That would be 1:26 p.m.
All right, thank you. Any other questions, sir?
Let me cross.
In the two exhibits we just watched, 13 and 14, you see anyone driving the vehicle?
No, I do not.
Do you know if anyone's in the vehicle at the time that you see it pull away?
I would assume, based on my training experience, that when the vehicle pulled away, that there was someone inside the vehicle, because in order to move a vehicle, you have to manipulate the controls, the shifter, the brake, the accelerator. So my assumption is that someone is inside the vehicle doing that.
That wasn't the question. Do you see anyone in the vehicle?
I object, Your Honor, that was the question, and he's already asked and answered. The question is, anyone can be seen.
The objections, I'm not sure what the objection was, but the answer may stand. You can ask your next question.
Let's go back to Exhibit 175. Can you pull that up for the witness?
Would the state please pull that up? Witness only or published?
Publish.
Okay, thank you. Go ahead. Jurors, let me know when it's in the jury box as well. All right,
just-
go ahead. It's in the jury
You
box.
just testified that this was the alleged defendant. How do you know that? Can you see a face?
Which question are you asking? Those were two.
Can you see the face on the circled individual in that exhibit?
In this clip, I cannot see the face of the person that is circled.
So how do you know who it is?
I can tell who that is because I have watched this video in its entirety, and I can tell that it is you based on all of my contacts with you.
So why were there not any other exhibits that can give credibility to you positively identifying the individual in this video?
Objection, argumentative,
Grounds.
compound.
Sustained as to the form of the question.
Is it fair to say that this is the only exhibit photo from the video?
Go
Can
ahead.
you clarify the only one that is shown today, or the only one that has ever been taken?
The only one that's
ever
the only
exists?
one that's
Could you clarify,
being
please?
shown right here today. Is this the only one that is an exhibit being shown here today?
Yes, this is the only one that we've shown today.
And you can tell just from this exhibit exactly who that individual is.
I don't believe that was my testimony.
I'm asking the question.
From just looking at this, no, but I know from looking at the entire video that it's you.
We're talking about this exhibit that's being shown right now during your testimony right now at this moment. Strictly that.
Could you ask your question, please?
I'm going to object, asked and answered.
Sustained as to the form of the question as well.
Would it be fair to say that from this exhibit 175 that they're looking at right now that you cannot tell who the circle individual is? Would that be fair to say?
That would be fair to say.
Can you clear the circle?
Thank you, Madam Clerk.
And do you recall what date you viewed this video, as you call it?
I have viewed this video multiple times. I don't recall the specific dates that I've seen it.
Was it relatively early on in the investigation?
There have been multiple times that I've watched this video. Some of them early, some of them as late as yesterday.
Do you recall seeing this video the same night of the incident or in the days following?
I did not see it the night of, but it would be the days following that I have seen it.
And at that time, did you have knowledge of who that vehicle belonged to?
Yes, I did.
And did you have knowledge of the usage of that video? I mean, the usage of that vehicle?
I'm not sure that I understand the question.
Did you have knowledge of who may have been using the vehicle?
Objection vague as to time.
Sustained as to the form of the question, if you could limit or perhaps direct him to a specific time frame regarding the use of the vehicle.
At the time of the incident?
Yes.
And can you clear that? And what information was that?
The information that I had is at the night of the incident that you, Daryl Brooks, were the person that were operating the vehicle.
And who did you learn that from? And for the record, I don't consent to that name.
Noted,
For the record.
overruled. Go ahead and answer.
Can you repeat your question, please?
I'm gonna go another route on this.
Are you done with the exhibit, sir?
No, I'm not.
So you're withdrawing your question?
Yeah, I'm going another route.
All right, thank you.
You just testified to seeing the entire video that this steel frame exhibit came from, correct?
I testified that this came from the entire video, correct?
You said that you viewed the video in its entirety, correct?
The entirety what we recovered from your social media account. I'm not sure if there is a longer version someplace, but
Did you see the video in its entirety? The video that this exhibit came from?
yes.
And are these the only two individuals that you observed in that video?
They are the only two that I recall seeing in the video.
Did you ever inquire about the identity of this individual?
No, I have not.
Can you clear that circle?
Thank you, Madam Clerk.
Would it be fair to say that from looking strictly at the exhibit that we're viewing right now, that both individuals have the same hairstyle?
It would be fair to say.
Can we clear the X's and clear the exhibit?
Go ahead. Thank you.
We go back to Exhibit 13. Publish.
Go ahead. The state would assist, please.
13. Can you play it? Well, just play it. I'll tell you when to pause if that's okay.
Go ahead.
It's not up yet.
Oh, thank you. We're gonna wait until it's in the jury box.
Okay.
Okay, go ahead. Thank you. Just as a reminder, it's 49 seconds long.
I don't think I'm gonna need the. Well, I don't know. Yeah, I might. Pause. Right there, the individual that you observe. Right here. Do you see them wearing a hoodie?
The person in that photo is not wearing a hoodie.
Do you see a hoodie anywhere present in this video?
No, I don't see a video or a hoodie anywhere in the video.
Can you take the X down? From this angle, it'd be fair to say that you can see the very front end of a vehicle, correct?
That is correct.
Can you see any windows or see inside the vehicle at that time? Or at the time that we're looking at right now?
You cannot see inside the vehicle at this time.
So it would be fair to say that just by looking at what we're looking at now, you wouldn't know if anyone's already inside the vehicle.
This has been asked and answered, Your Honor.
I'll allow it. The witness may answer.
This is a whole different.
I'm allowing it. Go ahead.
That is correct. From this video, you cannot tell if anyone else is inside the vehicle.
So it'd be fair to say that you're not sure.
It's fair to say that I am not sure.
Can we pull this down? Whoa, wait, I'm sorry, can you pull that back up for 1 second?
Same exhibit.
Same
Go ahead.
exhibit, 13.
All right. The state would put that back
Right.
on display,
It does-
and there you go.
The-
Do you want any
wait,
more of a plate or just the still?
We waiting for the jury, or do they?
It's up.
No, we don't need it played.
Do you need it to go to a certain point?
Yes,
All right, do you know what point?
I'm about to it right now. Looking at this house right here, do you see an address posted anywhere on this house?
In the photo that you circled, no.
So it'd be fair to say that you don't know the address of this house.
That is incorrect.
You just said that you don't see an address posted anywhere in this house. So from the vehicle, I mean, strike that, not the vehicle. I'm still looking in the corner right here. From the video that we're viewing right now, do you see an address posted anywhere on this house?
I do not see an address posted in this photo.
So judging by this, well, actually it's a video, but judging by this video, how can you know the address of this house?
Because I've been at this house before to talk with your mother. I've seen the address on the front of the house.
Judging by this video.
Hold on, you have to let him finish, because that was not the question you asked. You asked him how he knew. He can answer. Go ahead, Detective Casey.
I have been at this address before. I have spoken to your mother. I have been in the backyard of the residence. I've seen the address on the front of the house. I know this to be your mother's house. I recognize from this photo to be your mother's address at 4014 North 19th Street.
You recognize the house or the address? Because we don't see an address in this video.
I recognize this house to be that address from being there.
And had you already been there, as you say, and talked to people, as you say, before you viewed this video?
I believe that I saw the video first, and then I was at the address.
So at the time that you saw this video, you didn't know whose house that was?
That would be an incorrect statement.
You just said that you saw the video first before going to the house. Did you, or did you not say that? Would that be fair to say?
I guess I'm a little confused in your question. We received the video. We know from getting it from your mother that she said that that is where she lives. So I knew that this was where she lives when I watched the video. That was clarified for you.
I follow you, but that clarification wasn't stated before. So that's fair from the clarification of how you just clarified it. Can you clear the
Are you
circle,
done with
please?
this exhibit?
Yeah.
All right, we'll take it down. Thank you.
You made reference to a key being found. Did you yourself find that key?
No, I did not.
Were you at the scene where the key was found at the time it was found?
No, I was not.
So it'd be fair to say that you were told that a key was found.
Yes, I was told that a key was found.
So it'd be fair to say that you went off of what you were told. You actually didn't observe this with your own eyes.
What are you speaking of?
The key being found.
That is correct. I was told by two officers who I've worked with for a long time, and I trust what they tell me to be accurate.
you made reference to there being a couple, was the word you used, a couple ways to identify individuals, and you stated that you had spoken with the At that time, was the alleged defendant already in custody?
Yes, he was.
Wouldn't it have been easier to just use the fingerprints that were already obtained?
Like I said before, the fingerprints was one way. We also verified it talking to his family members that his identity.
Any reason why, or let me back up. It'd be fair to say fingerprints are pretty accurate though, correct? Would that be fair to say?
I think that would be fair to say.
So it would also be fair to say
Objection, that's compound and difficult to follow.
it's not compound. It's
Sustained
not
is to the
difficult
form
follow.
of the question, sir. Please
That was
rephrase.
very clear.
Sustained is to the form of the question.
And where did the interviewing of the mothers of these children take place, if you recall?
I spoke to Jessica Macklin in Iowa at her residence. I spoke to Angel Fitzpatrick at her residence in Menominee
Whoa, whoa, whoa,
Falls.
whoa, 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 whoa. Can we strike that? Why do the names have to be stated?
Overruled, he was answering the question. His answer may stand, your request to strike is denied, and the witness may continue answering.
I spoke to Angel Fitzpatrick in Menominee Falls at her residence, and I spoke to Erica Patterson a number of times at various locations about you.
You said one of the mothers of these children you spoke to in Iowa.
Correct.
Why would you go all the way to Iowa?
Because initially you listed her as a witness on your witness list for court. So we went there and we wanted to verify what information she might have that she would testify to.
Just for the record, I don't recall listing anyone as a witness, just for the record.
For the record, Mr. Brooks, you can't testify at this
know
moment.
that.
You'll have an opportunity should you choose.
I just wanted that clear for the record since what was
Can't be,
said.
it's struck from the record at this
I-
point because you're attempting to testify. The
I'm not
jury will
attempting to
disregard
testify. I
that.
just wanted the record to show
The
that I
jury
had no
will
knowledge of doing that. And if
The jury will disregard those statements made by the defendant
If
as
something's-
that he is not testifying, and it would be improper at this time for the court to receive them.
well, I don't think a
Go-
record should be
next
made of
question, sir.
something that I didn't do.
Next question, sir.
It's ridiculous. So you said you went to Iowa to try to find out what would be testified to. Why?
Objection, argumentative,
Grounds.
irrelevant, and calls for hearsay.
Grounds.
Sustained as to all basis. Next question.
Was that an attempt to prepare for what might have been said?
I'll allow that.
Okay.
Go ahead.
Yes.
Why would there be preparation involved in someone who might testify on an alleged defendant's behalf?
Objection, argumentative.
Grounds.
Overruled, I'll allow it.
We went there to speak with her, so if she came in and testified, there wouldn't be any surprises. We also wanted to find out if there's any background information that she had about Mr. Brooks that would be helpful in our investigation.
So you made reference to not being any surprises. Would it be fair to say that there was a little worry there?
Objection, argumentative.
Grounds?
Sustained as to the form of the question.
What surprises were you referring to? What do you mean by surprises? No surprises.
Your Honor, I object to this entire line of questioning. This witness is not expected to testify. It's wholly irrelevant.
Well, he opened the door by putting the name on the record and saying where he went.
I will allow one more question on this. Go ahead, you may answer.
Could you re-ask the question, please?
What do you mean by making sure that there were no surprises?
We wanted to make sure that there wasn't any information that we weren't aware of that may come up later that would be helpful in the trial.
Do you recall making an attempt to interview the child
Objection, relevance.
who was 7 at the time?
Sustained as to, next question, please.
Reason for the sustain, Your Honor?
Not relevant.
Well, the question was asked, does he recall?
Sustained, next question, please.
Grounds for the sustain again?
Relevance.
How is it not relevant?
Keep going, sir.
Did you interview the child?
Same objection.
Grounds?
Sustained.
Grounds for the sustain?
Relevance.
Why would you ask to interview the child?
Your Honor, objection. This
Sustained.
entire line of questioning is inappropriate.
Sustained. Move on.
I would
Mr. Brooks.
object that trying to interview a 7-year-old child is,
Sir, move on, please. 90611. It's also not relevant. Assumes
very
facts not in
relevant.
evidence.
It was a tricky move. You made reference to, in regards to Exhibit 88 and 89, which were documents from an entirely different county. Do you work for Milwaukee County?
No, I do not.
So how did Milwaukee County, which is a different county, come into your investigation in Waukesha County?
You may answer. With the understanding there are some limited pretrial rulings that still are in play. Go ahead.
During the normal...
I'm sorry for interrupting. I started off by saying in regards to Exhibit 88 and 89. That's how I started the question, just for the record.
I know. I'm reminding the witness of the pretrial rulings.
Okay.
During the normal course of an investigation, we do background on a person to see if they have any open cases or any information that would be helpful. There is a computer system that displays what cases or charges are open for a person, and it is relevant because if you are charged in one county and you violate conditions of bail, you can also be charged in another county for those violations.
And in reference to having charges in one county and potentially being charged in another county in reference to that. Wouldn't you essentially have to violate the conditions in one county and strictly be charged in that county?
That is an inaccurate statement.
You being in law enforcement for a very long time, it would be fair to say that you're familiar with the term double jeopardy, right?
I have heard the term before.
And what is your understanding of what that term means?
Objection, irrelevant, beyond the
Grounds.
scope of the witness's knowledge, legal conclusion.
Sustained for all those reasons.
So when did you become the lead investigator in this matter?
It was about 8:30 p.m. on November 21st, 2021.
So same night.
Correct.
And whom were you made lead investigator by?
The command staff or Lieutenant Jerry Habanik.
Do you recall why you were tapped to be the lead investigator?
Because I was the most qualified person and had the most experience to take care of it. That's what I've been told.
Any other reasons besides that?
Also because I was at the parade route a little bit earlier and I had the most information out of anyone. It took a little while for the other staff to come in, so I already had a little bit of a head start with the information that I already had learned as being there at the beginning.
And that would be in the information that you said you had more knowledge of than anyone else at that time. Would that be in reference to having an interaction with the vehicle at some point?
I would say as the totality of the situation, I was there when the car first went through. I know what the radio traffic was for taking Mr. Brooks into custody. There's also some decisions that were made early on how to proceed with the case. I was also on scene downtown and took control of the crime scene initially. So a lot of those decisions were made even before our command staff started coming in to take over lead on the case.
When you referenced you were there at the beginning when the vehicle first entered in the parade. What do you recall about when the vehicle first entered the parade?
I remember a horn beeping, red Ford Escape driving around, and then you driving into me and not stopping when I pounded on your hood and window.
Driving into you, what do you mean?
I meant that I was in front of your vehicle contacted me, pushed me off to the side, and continued driving without stopping.
Were you injured in this incident?
I was not injured, thankfully.
And you made reference to a horn beeping. What do you mean a horn beeping?
I mean,
The vehicle was beeping its horn?
Yes, the vehicle was beeping its horn.
What would be the only time a vehicle would beep their horn?
Objection,
Grounds.
speculation.
Sustained. Calls for
Reason.
speculation.
Do you know why the vehicle was beeping their horn?
Same objection, Your Honor.
Do you know why you would beep
He
your
asked,
horn?
do you know why? So he can answer that question.
Could you repeat the question, please?
Do you know why the vehicle was beeping its horn?
I imagine that the driver was angry and wanted to get through the crowd.
And how did you come to that determination?
I've been driving a long time, and a lot of times people get angry, they're late, they beep their horn at you, and way that is because they're upset and they're trying to get past you.
Do you know that for sure?
You asked me my opinion.
Yes, I did ask your opinion. Now I'm asking you, do you know for sure if the driver of the vehicle you observed was in fact angry?
I assume that he was.
So it would be fair to say you don't know for sure.
I do not know for sure, but that is my opinion, is that he was angry.
And at that time, you had no knowledge who the driver was. Would that be fair to say?
Well, I had knowledge because I saw your face. I did not know your name
Did you
at that
know
time.
who the driver was? No, meaning had you had any prior interactions with them before this incident? That's what I mean by no. Have you had any conversations with him, talked to him?
Hold
saw
on,
him?
compound question, ask one.
I was just giving clarification of no,
You
what I
need
meant
to-
by
It's a
no.
compound question, please rephrase.
Before you observed this vehicle, as you say, and this driver that, as you say, did you know them?
I have no memory of meeting Mr. Brooks before that afternoon.
So it'd be fair to say that you're assuming something that you don't know. Would that be fair to say?
Objection, compound, vague, and argumentative.
Sustained.
Grounds?
Sustained as to the form of the question.
How would you know how someone's feeling if you don't know who they are?
Your Honor, he opened the door to this. It's asked and answered. The witness has given his opinion. It's clear.
Grounds?
I object. Improper question.
Grounds?
I will allow the witness to answer why he came to that conclusion. Go ahead.
Like I said before, I've been driving a long time, and a lot of times when people are beeping their horns, it's because they're late, they're angry at something happened, and that's why I concluded that the person was probably angry.
So would it be fair to say that another reason why a vehicle would beep its horn would be to alert people to the presence?
Objection.
Grounds?
Irrelevant speculation.
Grounds?
I'll allow it. Based upon his training and experience, he may answer.
It's a possibility.
And did you hear this beeping before the vehicle approached you?
Yes, I did.
You made reference to, and I'm referring to the ring video obtained in exhibits 88, or I'm sorry, the ring video obtained in exhibits 13 and 14. You made reference to obtaining that the same night of the incident. Do you recall saying that?
Yes, I recall saying that.
And it would be fair to say that you yourself have been present for all testimony. Would that be fair to say?
That is not correct.
How so?
I was sick one day and I was not here.
Well, I'm referring to, let me clarify. Maybe I wasn't clear enough. Pertaining to all testimony since trial began, you've been present for all testimony. Would that be fair to say?
I believe I've seen most of it.
Do you recall testimony of and I'm referring to, again, so clear for the record, exhibits 13 and 14, ring footage that was obtained by the owner of 4014 North 19th Street, that you testified to obtaining the ring footage the same night. Were you aware that, well, let me back up just a little bit. How were you able to obtain that ring footage?
There was officers that went to Freighter Hospital where Dawn Woods, Mr. Brooks's mother, was working. They spoke to her, and she's the one that alerted to them that she had ring video at the house and offered to remotely download that video for them.
And were you there yourself?
I was not there myself.
When did you yourself speak to the owner of that home?
The last time that I spoke to Dawn Woods was on August 8th of this year. I may have spoken to her a few times before that. I don't recall the exact dates.
I'm referring to the first time that you spoke.
I don't recall
Very first time.
I don't recall the first date when that was.
And you did just make reference to an August 8th date. And what was the extent of that conversation?
Objection calls for hearsay.
Grounds?
Sustained. Hearsay.
The August 8th date that you referred to, was that in any way follow-up? Was that follow-up investigation?
Follow up to what?
Well, you stated that you had spoken previously before the August 8th date. So the question is, was the August 8th date follow-up to the investigation that you were already actively lead of?
I mean, everything is related to this investigation. The
So-
investigation continues every day. It will not end until this trial is over.
So what follow-up was needed at the time of the August 8th interview? I'm guessing that's what you would call it. I don't know, I'm not sure.
Objection still calls for hearsay, Your Honor.
Sustained.
Why did you need to talk to Ms. Woods multiple times?
Because every time we spoke to her, we got different information, and at that time we were following up with your niece and nephew of what their testimony would be in this case.
What testimony are you referring to? Because I don't recall any nieces or nephews testifying.
I don't think I'm allowed to say it.
I think this line of questioning is irrelevant, Your Honor.
I'll sustain the objection, and at an appropriate break, I can address it further if need be. Please move on to a new topic, sir.
You made reference to people who were injured at the parade inadvertently. You recall that?
Yes, I do.
To your knowledge, were any of those charged?
My testimony before is that those people's cases were not charged.
And were they seen as victims?
Going to object to the form of that question. I think it calls for a legal conclusion, Your Honor.
It does not. I asked to his knowledge.
I'll sustain the objection as to the form of the question, if you could please rephrase.
I'm gonna go a different route. Do you recall serving a warrant to the Waukesha County Jail on July 1st of 2022?
Yes, I do.
Do you recall what that was for?
Yes, I do.
And what was that for? Can you state for the record and for the jury?
It was for Mr. Brooks's jail cell.
And why did you serve a warrant for a jail cell?
Your Honor, I object pursuant to legal rulings previously issued in this case. I don't think this is relevant.
I'll sustain the objection. It's not relevant. I'll certainly take it up at a later point if need be.
What was the warrant pursuant to?
I sustain the objection. Next topic, please.
He did answer.
I sustain the state's objection. I'm directing him not to answer. We'll take it up separately. I'll have you continue with your cross-examine. I'll take it up later.
You made reference to this vehicle driving into you, but stated you were not injured. Did you file a claim in this matter?
No, I did not.
Do you consider yourself an injured party in this matter?
No, I do not.
Do you yourself know if anyone filed a claim in this matter?
Can you be more specific?
Do you yourself know if anyone filed a claim in this matter?
Just in general?
Whatever your interpretation of that will be.
I would say yes.
And do you know what that claim was?
I would imagine that there was a lot of injuries from the people. A lot of people had very extensive medical bills. I imagine that they would file a claim with their insurance company to have those bills paid.
So you had knowledge of what was filed to their particular insurance companies?
I have no knowledge, but my assumption is that they would have filed those bills.
So it'd be fair to say you don't know for sure.
That was my testimony.
Is that the answer?
Yes.
as lead investigator for this matter, where are you, to your knowledge, aware of any GoFundMe type of things?
Objection
relation to-
relevant? I'm sorry.
Do you mean as it relates to?
As it relates to the incident.
Overruled, the witness may answer.
I have no direct knowledge, but I assume that there are some GoFundMe pages out there. It's typical in something like this.
And what do you mean by typical? You've seen this before? Is that what you mean by typical?
We have a very loving and caring community where a lot of times when bad things happen to people, people pull together and offer financial assistance to help people.
Is it fair to say that there's a lot of communities like that across Wisconsin?
Yes, I think there are.
And it would be fair to say that you've worked extremely close with the district attorney's office during the entirety of this matter. Would that be fair to say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
I would like you to define it. Extremely.
I'll answer yes if that helps.
To your knowledge, do you know if it's typical for a lead investigator to sit right behind the prosecution table at a trial?
Yes, it's very typical. It happens in most larger cases, especially a case of this magnitude. There would be a court officer. So yes, that's a very typical thing that happens.
Have you ever done this before?
I've done this multiple times before.
And are you the only detective in the investigation that has that honor?
Objection vague?
Grounds.
Sustained as to the form of the question.
Are you the only detective directly involved in an investigation that sits with the prosecution?
Talking about this case or any case?
This particular
or-
case.
I'm sorry, you interrupted me. Could you repeat that, please?
I believe he said this case.
I'm referring to this case, yes.
Could you re-ask the question, please?
Are you the only detective actively involved in this investigation that sits with the prosecution in
Yeah.
reference to this case?
Yes, I'm the only person, the only detective that's sitting with the prosecution during this trial.
So would you explain who the other officer is in the blue suit over there?
Objection to the relevance, Your Honor.
Grounds.
Sustained.
I just want to know his role.
Sustained. Next
Reason
question,
for the
please.
sustain.
Not relevant.
He's been in the courtroom the whole trial. How is it not relevant?
Mr. Brooks, next question, please.
Nobody knows who he is. That should be known. Nobody said
It's
that.
not relevant to the issues that the
jury
jury needs to determine. Next question, sir.
is asking. We're telling. I'm assuming that's asking.
Do you have a question, sir?
Yeah, I do. I would like to get to it. Thank you.
Please do so. Thank you.
I will. So seeing as how you sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim?
Objection,
Grounds.
legal conclusion.
Grounds.
Sustained.
You are aware that only a living, breathing human being can actually file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Objection,
You
move
are
to
aware of
strike.
that, right?
Go ahead, Attorney Upper.
Move to strike the statements by Mr. Brooks. Also object to the question that was asked at the end as irrelevant, argumentative, and calling for a legal conclusion.
Objection is not calling for a
The-
legal conclusion in any way.
The court sustains the objection. The request to strike the statements made by Mr. Brooks are granted, or the request is granted. The jury will disregard the statement and the question asked for all of the reasons indicated by the state. It also is a misstatement of the law.
No, I definitely object to that, Your Honor.
Your objection is noted. I'm going to have the jury stand for a second. They've been sitting for quite some time, and then you can formulate your next question.
I'll take exception to that ruling. And would like a legal finding of fact.
Your objection is noted. It's overruled.
And that's a judicial determination.
All right, thank you. Be seated. Go ahead, Mr. Brooks. Please continue with your questioning.
Have you ever had any interactions with this entity, state of Wisconsin?
Mr. Brooks, under 90611, I'm not going to allow the witness to answer. It's vague.
There was no objection.
Under 90611, I shall exercise reasonable control over the mode and order of interrogating witnesses. Please, next topic. These questions we addressed during the initial cross-examination of this
They're
witness.
gonna keep coming up.
And I determined at that time that they weren't relevant. So next topic,
They're gonna
please.
keep coming up.
Under 90611, sir, please move on to a new topic.
They're gonna keep coming up.
For the cross-examination, I will end.
Do you see the state of Wisconsin present in the courtroom today?
Objection, argumentative,
Grounds.
irrelevant.
Sustained. Final warning, sir. Next topic or the cross-examination, I will
You
bring it to
don't
an
gotta
end.
keep. You don't gotta keep doing that, Your Honor. You don't gotta keep doing that.
It's my responsibility, sir, over this trial.
I'm informed. And
Thank you.
And I
Next
respect
topic.
that. But it's relevant for the jury to know the truth. They deserve to know the truth.
Move to strike, Your Honor.
Granted, the jury will disregard
Objection.
those last statements. They're
Objection
not
to that.
relevant. Mr. Brooks is not testifying. They mistake the law.
I object to that. That's not lawful law. It's
Noted.
untruthful.
All right, under 90611, I am now stopping the cross-examination. Any redirect by the state?
Objection to that. And I would like
Noted.
a legal finding of fact.
Attorney Opper, any redirect?
Yes, just very briefly, Your Honor, I would like to display for the witness only Exhibit 178.
Objection.
I haven't seen the exhibit yet, so I'll take
Well,
that under
I'm
advisement.
objecting still because the
You may show it to the witness.
there needs to be an answer to why the jury's not being told information that they deserve to know.
Go ahead, Attorney Opper.
Your Honor, for the record, this is a video I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
And this seems, objection, because this seems like a whole new exhibit. This was never mentioned before. It was never,
I haven't seen it, I can't rule on it, sir, so let
I
me
mean,
see it, and I'll
when
take
did
your
it become an
objection under,
exhibit?
I'll
It
take the
was never an
objection under
exhibit before.
advisement. Go ahead.
I haven't seen this in any of the exhibits that I have, so how could it just be created now and be made an exhibit?
Go ahead,
I
Attorney
have all the
Hopper.
exhibits.
Go ahead, Attorney Hopper, I haven't seen it yet, there's nothing on my screen that I can see. I see it's now playing.
So now we just create exhibits now. I have all the exhibits, and this was never in it. Oh, man.
All right, you can stop. Sir, do you recognize what's contained in State's Exhibit 178?
Objection,
Overruled,
relevancy,
overruled.
leading.
Go ahead and answer.
Yes, I do.
What is it?
Objection, leading.
Overruled, the witness may answer.
You still don't, I'm still gonna object. How's this?
Mr.
have
Brooks, I
all-
ask that you honor
I have all
the ruling that I've
I have
been
all the
made.
exhibits though, Your Honor. I have them
Mr.
all.
Brooks.
They were provided to me, and this was never in the exhibit, so how could it just be made an exhibit
I'll take
just
this
out of
up
the blue?
outside the presence of the jury, but I'm gonna allow it.
Can that be stated for the record? Can that be explained?
No, the jury will disregard the statements made by Mr. Brooks. They're not evidence, and the statement
So this
continue.
exhibit shouldn't be evidence then, because it
Mr.
didn't
Brooks, the
exist before
objection's
today.
noted, it's overruled. Go ahead.
There was a still photo shown before of Mr. Brooks
This is
standing in front of the
mind-boggling.
Ford Escape. This is the video in which that still photo was taken from.
You could
Objection, how
re-
does he know that?
Overruled. The witness may answer. I'll give you the opportunity to question him about it when the state's done asking the questions. Go ahead.
Where'd you get this video from, sir?
Objection, leading.
Overruled, the witness may answer.
From Mr. Brooks' social media account.
Okay. Your Honor, move to admit 178 and permission to publish.
Objection to the relevancy.
I'll
And
find that
still
it's
don't know how it
relevant.
was
I'll
obtained.
receive Exhibit 168. Permission to publish is granted. For the record.
It's
could you please-
178, Your Honor.
No, could you please tell me the length of the video?
The length is 2 minutes, 33 seconds. We're going to play it in its entirety, but without volume, Your Honor.
All right, thank you.
And
I object to that, and I would like to make an offer of proof for my appeal.
We'll do that outside the presence of the jury, but I will allow the state to play it in its entirety without audio.
Your Honor, I have all the exhibits. They were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to
But
address.
how can you play something that's not, that I didn't even
Mr. Brooks,
have?
I'll take that up outside the presence of the jury. But
This
your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
Mind-boggling.
actually, Your Honor, I changed my mind. I would like to play the audio, please.
This is mind-boggling.
I want to have it played first without, and then I'll make a ruling and I'll take that up.
Okay, I understand.
Thank you.
So we will play the entire video, Your Honor, 2 minutes, 33 seconds.
I object to that. Why does the whole video need to be played? Is this setting the foundation?
It's relevant. You questioned the officer about it. You
I
questioned this
question him
detective
about,
about
I
his
question him
knowledge.
about the still frame from the video. The video wasn't even in the exhibits that I received. I actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop. The jury will disregard his statements. He's not testifying. The video's playing.
So play the sound. I want to hear it now.
I'll address that later.
We address why it was created out of the blue too.
Go ahead, attorney, after the video is finished playing.
Thank you. Sir, did you see during the playing of that video the image that was captured as a screenshot and presented to you in your direct testimony as states exhibit number 175?
Objection leading.
Overruled, foundational, the witness may answer.
Yes, I
A
did.
lot of
You were questioned on cross-examination as to your ability to identify Mr. Brooks in exhibit 175, correct?
Objection. That question was asked initially by Attorney Hopper.
Overruled, the
Yeah.
witness may answer. Sorry.
Yes, I was.
As you just watched the entire video again now in court, as states exhibit 178, did you clearly see Mr. Brooks in that video, sir?
Objection leading.
Overruled, the witness may answer.
I believe there's no doubt that that's Mr. Brooks in the video and later standing next to the Ford Escape.
Thank you. I don't have any other questions, Your Honor.
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Casey.
Objection. I don't consent to being called that name. And yeah,
Noted.
I
Do
got
you
a
have any
question.
questions for the witness?
This when did this video? When was this made a exhibit? Because I don't have it.
Objection. That's not a question for the witness, Your Honor.
That
Sustained.
was a question. When was
Sustained,
this
as to the
video
form
made
of
an
the
exhibit?
question.
When was this video made an exhibit? That is a question.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
Sustained.
Well, he said he saw it.
But that's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
With the understanding that you're asking when did he see the video, I will
When
allow
did
the
you see
question
this
to be
exhibit?
asked. With that understanding, you may answer, Detective Casey.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table? It would be the same thing. I'll take that as disrespect because they were allowed to say something and I said under my breath that was disrespect.
I
They
would
just
direct
did the
both
same
parties
thing.
to avoid commentary.
Okay, well, can
and
you do that,
gestures
please, and
faces.
admonish them?
Yes,
Because
I
I'm
will.
always the one getting
Absolutely.
admonished.
Everyone.
I take that as disrespect too.
Sir, can I do my job? State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody
However,
ever see nothing.
I'm advising both parties to show
Come on, man,
decorum
this is not fair.
and restraint, to
I
be
will.
respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey, you can answer the question about when you have seen this video prior to today.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
Why did you need to review it this morning?
Objection, argumentative.
Overruled, the witness may answer.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a
Grounds.
misstatement, Your Honor.
Sustained
it was
as to
not
the form
brought
of
up
the
in
question
the
assumes
testimony.
facts not in evidence.
If you have seen it numerous times before today, why did you need to see it again to make sure if any questions were asked, or however you refer to it? What would be the need to view again this morning something that you had viewed numerous times before?
I'll see with my
Objection,
Hold on.
objection, compound, asked and answered, misstatement of the facts, argumentative.
Sustained.
Did you view the video this morning because you knew that the video would be made an exhibit this morning?
Objection, assumes facts not in evidence.
Sustained as to the form of the question.
This is mind-boggling. This is mind-boggling. Can you clarify again why you viewed the video this morning?
Objection, asked and answered.
Sustained.
So you're gonna sustain everything?
It was already answered, sir. Next question, please.
And I'm asking for clarification.
Next question, please.
I don't got no more questions, man.
All right, thank you.
This is mind-boggling.
Detective, you may step down. I'll excuse the jury.
What you people was trying to do is not fair. Hide things from the jury repeatedly. You don't tell them all the information
Mr.
they
Brooks,
need
I'm
to
going
know.
to take up all of your objections outside the presence of the jury. I'd ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's the only reason, because you asked. I see what you people are trying to do. It's not right. It's not fair and it's not right.
You can have a seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence. All right. First of all, Attorney Hopper, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated
Mr.
by
Brooks, I need to
something
make
that I
a
saw?
record, so just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
All right, based upon the offer of proof provided by the state, and it was provided to prior counsel, that satisfies me as to that issue.
That's
I
inaccurate.
indicated I
That's
would-
inaccurate, Your Honor. Can we have the prior counsel testify to that then? Because
Not at this time, sir.
I have not obtained that. Right now, that was my first time seeing that as an exhibit.
Mr.
That's why I
Brooks, I
raised the
presume, and you can correct me if I'm wrong, but you're familiar with that video? Yes or no?
What does that have to do with what we're talking
Because
about?
I'm going to make a finding based upon what I viewed in that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons, the first of which it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that, and what relevance, if any, that evidence have, but you opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it because the still image was of your back.
Okay.
So that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists, and that is my finding as it relates to that.
What do you mean by it's no surprise to me that it exists? That was not the issue. The issue was how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue
State can make
didn't
an
have
offer of
anything to
proof
do
on
with.
that, because obviously they marked it as an exhibit. They
But with
had
all
it, so
respect,
go
Your
ahead,
Honor, you're
Attorney Opera.
mischaracterizing what I said, and the record needs to be clear. The issue that I raised was how does this, at the last minute, out of the blue, become an exhibit?
Attorney
That
Opera,
was the
go
issue.
ahead and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well
Objection.
aware.
He said social
There's
media. He
nothing
didn't
that
say what it was.
Sir, stop interrupting. We have to make a record of it. You've
Then make the record
interrupted multiple times. I've been abundantly patient
record
with
clear.
you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at
asking
me.
me to be quiet?
Stop rolling your eyes at me.
Are you?
Stop
I'm
mumbling.
looking right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and
looking.
I've made note
I'm
of
looking
it.
at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Go ahead, Attorney Opper.
Thank you, Your Honor.
gonna take that
And
as
just
asking.
to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him to sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did because he pushed it again, and his voice and his mannerism of speech, I thought would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up, and whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks because, again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up two other issues. There was an objection to questions regarding cross-examination. So the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction, I believe it was with your mom, and possible testimony of your niece and nephew?
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
I don't know specifically what you're talking about,
There's a reference
sir.
made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling on an exhibit.
She's been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
I haven't made any of those observations,
I didn't
sir.
say
What
you.
I've observed,
I didn't say you, Your Honor.
No.
But
What I've observed is
listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot.
Nobody
That is
said
very
sir.
disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't
Her
know what you're
laughing under her breath. Her trying to cover up the microphone so they can laugh and he and key. That they've been doing that the whole time. I didn't say anything. I didn't say anything about it.
I have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I haven't noticed that other than the one thing you pointed out.
Well,
today,
we have cameras. That's what the cameras
Mr.
are for.
Brooks, let's refocus our attention on what we're here for, and that's
Okay,
this trial.
then I take that
and
as.
do you have
I
anything you
take
want to
that
put on
as-
the record?
I'm putting it on the record
As
if I
it
get a
no,
chance.
you need to let me finish. As it relates to the video and my decision to admit
She
it.
just admitted that she just now came with the exhibit. It was not. She just said. She just made it an exhibit. It
That
was
doesn't
not
mean
an
it wasn't
exhibit
turned
before she
over
made
to
it
you. So
one.
do you have some legal basis, sir, for your position? Because I'm
What
not
do
aware
I
of
need
any.
legal basis for when she just admitted on the record that she just made this exhibit up
No,
right
she
now?
didn't. That is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't
Create
implying that
the
by saying
exhibit.
that she could
She did
pull
not make
anything
it up.
out of her suitcase.
So that's a figure of
During,
speech.
okay, so what is
Alright.
it implying to? What would that be implying to?
As attorney,
How would anyone-
all
how
right,
would
I'm
anyone in
moving
my
on
position-
because you're not providing
How
me
would-
with any
how would
legal
any-
basis.
I didn't even finish.
For me
You told me that I can make the record. I'm attempting
Sir,
to make the
well,
record.
Sir, as it relates to the video and my decision to admit it, do you
I
have
just said
anything?
that you didn't even let me finish.
You're not letting me finish.
You didn't let me finish either, Your Honor.
Because you're not providing me. You're
But how
on a
do you-
rant,
how do you know I
you're
wasn't getting to
providing
that if I didn't
commentary,
finish?
You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes.
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that?
The bottom line is you opened the door to
It
the
doesn't.
playing
It
of that
doesn't.
video.
We're not talking about
And the
opening
video
no
was
doors.
previously provided to you during discovery.
We're not talking
There's
about opening no doors. We're talking about being fair.
There's
Because
absolutely
if I
no
would have did
prejudice
that,
to
Your
you
Honor,
in
with all
terms
due
of
respect,
surprise
with
by
all
the
due respect,
exhibit.
if I had
Right.
done that,
I am going to move on.
if
from
I
this
had done
topic.
that, it would have
Mr.
been a
Brooks,
big
I'm
thing.
advising you
Are you
that
asking
you
me?
I'm advising you, sir.
Oh, okay. I
I'm
don't know what that
advising you
means.
to sit down
I
and
don't
be
know what that
quiet.
means.
And if you interrupt me again, you are on notice that you will forfeit your right to be present
So
in
you're
this
holding me in
trial.
contempt
Mr.
for the
Brooks,
entire trial? Did you say the entire trial?
I never said any such
You said
thing.
for the trial. So what do
Please?
you mean? I'm asking. What do you mean?
Mr. Brooks, you continue to
That is
come
not.
at me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you. I'm not.
I'm
But
going to give you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and be quiet so I can make a finding
Are you
as it
asking
relates
me
to
to
other
do
things.
that? Are you asking?
I
me
don't
to
need
do
to
that?
ask, I'm telling you. Thank you. There were two other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August, and there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics, is my first question.
Okay, why was it an issue with me bringing up
Mr.
the
Brooks,
jail
I'm
search?
only gonna ask you one more time, and if you
I'm
don't
saying
answer it
if I don't
correctly,
understand,
then I
if I
will
don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Man,
It calls for
I
a
don't like
yes or
I don't
no.
like your tone and the way you're talking to
It-
me. I don't.
Mr.
I don't
Brooks,
appreciate it.
Sit down. I don't care if you
No,
don't like my
I'm not
tone.
gonna-
You've
I'm
been
not gonna
pushing
sit
my
down.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too?
the utmost of respect
No,
for
you
you,
haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to
don't.
call it, that's fine, but it's not
Stop
accurate.
talking.
What you mean stop talking?
I need to make a ruling. Okay,
Well,
I'm purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's talk to
now.
each other like adults then.
Mr.
Because
Brooks,
I've never told you to stop talking.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the
All
question
right,
about
he's
the
not
jail
answered
cell?
my question. We'll move on.
I'm
not
trying
giving
to
that
understand. If I
All right,
don't
we're gonna take a
understand,
break.
how do
We're
I
in
know?
recess, 15 minutes
How do
from
I
now.
know
Thank you,
what I'm
everyone.
supposed to answer if I don't understand? And I don't agree to a stop.
the record in State versus Brooks appearances are as they were before.
I think the audio needs to be turned on.
Yeah, let's do that. All right, let me do that again. We are back on the record. State versus Brooks appearances are as they were before.
I don't consent to being called that name for the record.
Are there any issues related to exhibits or other things before I bring the jury back out for what I believe will be the state resting?
No, Your Honor, I do believe that I did check with your clerk. Everything that we have offered and admitted matches what the court has, so I believe we are good on that.
I had one question
Okay, sure.
about Exhibit 89, and I don't know if I missed in my notes.
Okay.
What do the parties' notes reflect on whether that was received?
I showed that it was offered and admitted before it's published, or it wasn't published to the jury. But if not, we would move Exhibit 89 into evidence.
And do you recall what Exhibit 89 is?
It's a
Otherwise-
certified bail form.
No, I'm asking,
Oh.
I'm asking Mr. Brooks.
Oh,
So,
sorry.
that was the second of the 2 bail bonds. Do you have a recollection of whether it was received?
I don't.
All right, then
I
what was?
know I objected to it.
I know you objected when it was, I think, displayed for the witness who then testified about it. I'll receive it and also advise the jury. Were there any other exhibits? I have one other issue on evidence and exhibits as well, but are there going to be any other exhibits that we need to tidy up the record in front of the jury with?
I don't believe so. I know at one point, someone caught that we moved, it was either Exhibit 175 or 178 into evidence, and the court admitted either 165 or 168 on the record. So I don't know.
So I may have just
I
had a
think you
misspeak.
Yeah.
You have any recollection of that, sir?
Recollection of what?
Related to what the state just put on the record. Do you know what what witness that was?
That was Detective Casey.
Look at that. $175 was the screenshot taken from the video. I know I have a note that it was received and published. And you believe I may have just referenced it by the wrong name?
I thought it was 178. I thought you referenced it by the wrong number. So it's either 175. 175 was referenced as 165, or 178 was referenced as 168.
What is 170? I know that 175 is what I just said.
Correct.
What was 178?
178 was the video.
Oh, that was the
video.
most recent one. Okay. What's the request then as it relates to when the jury comes back in?
Your Honor, I just, there's 2 different ways to do this. I can put on the record, I have the exhibit numbers, and I can just put on the record just to verify that these exhibits have all been offered and admitted into evidence, and the court's agreeing, because we've just agreed that those are, your records are the same as my records, or we can clarify just if there was some confusion about exhibits 175 and 178 that were shown to the jury this morning. Those 175 and 178 were offered, and the court has admitted those into evidence. So however you want to.
All right, sir, do you have any position on how I address this in front of the jury?
Yeah, I'm objected to him being admitted at all.
Well, those objections were already addressed. I'm talking about how I addressed to make sure the jury knows they were received by the court.
However you gonna do it is how you gonna do it. I don't think what I gotta say much matters.
Well, what you say matters, sir, but
No,
the
it don't.
fact that I've already ruled on the
Definitely
admissibility is not something I'm gonna revisit.
What I gotta say
Hold on,
definitely
that door is, all right, it's, sometimes that door upstairs malfunctions and, all right, I didn't hear the last part of what you said.
what I have to say about anything definitely doesn't matter.
I take huge objection with that, sir.
It's true.
And that may be your perception, but that is absolutely not true. This court takes your positions on evidence, legal arguments, admissibility, things of that nature. I take all of that quite seriously.
But somehow it's always overruled or discarded.
Sir, can I keep going because you've interrupted me once again? My perspective on all of this, sir, is when you disagree with a ruling, you interrupt, you try to debate the topic again and again, you make disparaging remarks either directly or under your breath that are audible. Sometimes you roll your eyes. I mean, just previous to the break, you and I were talking over each other. I couldn't really get a word in edgewise. You wanted to debate topics that I've already made decisions on. I wanted to get clarification on whether you wanted to pursue any questioning, for example, with Detective Casey. I gave you multiple opportunities to answer questions directly. You chose not to do that. You directly challenged me about my authority in this courtroom. You refused to sit down repeatedly. Did I raise my voice? I absolutely did. Was I frustrated? I absolutely was. I'm sitting down. My voice is calm. I think the break was good. I hope for all it was good for me. We had had a very long morning. It was about 11:30 when we broke. It's now 11:54. I didn't remove you to the other courtroom despite my repeated warnings because frankly I knew I was going to take a break. I just wanted to get through some issues outside the presence of the jury, which is the proper procedure for how to address objections if the record can't be done in a way that when a more full record needs to be made is how I'll put it. And I indicated during the cross-examination of Detective Casey, I would take your objections under advisement. I would address them outside the presence of the jury. You chose not to answer my questions, and so I moved on.
I chose not to
Now,
answer
with
you.
respect to, I want to also address exhibits and the normal course of exhibits coming in a trial. Because I think there's some misunderstanding and certainly confusion on your part, sir, about the exhibit list that I asked the state to file near the beginning. And that was frankly to assist the court and my clerk in keeping track. Most trials, the normal course of action is as long as an exhibit has been provided to a party previously, or in some circumstances, if not, it's rebuttal, we're not quite there yet, that as long as it's been turned over in discovery, oftentimes parties will simply have exhibits marked as they're presented in the course of a trial. There's not a legal requirement unless a judge orders it that would prohibit a party from marking a document that's been already exchanged and having it offered as an exhibit. There was nothing improper about what the state did with Exhibit 178. And I want to make that record very, very clear. As Attorney Opper stated, trials are fluid. Things happen. Parties can open the door to what might be inadmissible evidence for a variety of reasons. For example, this court made a number of pretrial rulings related to other acts evidence. Even during your cross-examination today, you came awfully close. I had the witness turn to me and pause and say, I don't think I can answer that, in a clear recognition that that witness, Detective Casey, understood his obligation to honor the pretrial rulings. And we moved on from there. I bet that's happened a half a dozen times in this trial. And that's frankly to protect your rights, sir. The door could have been opened a long time ago to the other acts evidence with Erica Patterson. And I frankly kept it out, despite your questions. So, with that, I want to bring the jury back out. I will ask the state, I'll simply just ask the state, are there any anything additional the state's offering by way of testimony or exhibits? You can then address the exhibit issue. Then I'll ask the state if the state has any additional witnesses, and the state can officially rest. Given the time of day that it is, it's 11:58. I'm not going to have Mr. Brooks start with his opening statement. We'll do that when we come back after the lunch hour. I think, frankly, the time over the lunch hour will be good for everyone to regroup, hopefully get a little bit to eat, and come back fresh. And then we'll have his opening statement and the start of testimony. Before I bring the jury out, there's one other thing I want to do, though. I just need a moment to pull something up from on my computer.
So is that addressing subject matter jurisdiction that you're pulling up?
No.
When would that be proven for the
Sir,
record?
please don't interrupt me. I need to focus on what I'm
I'm not
doing.
interrupting you. I'm just asking a question.
All right. I'm not going to be addressing that.
So would it be
Don't
proven
interrupt
on-
me right now. I'm trying to do something on my computer.
Would it be
I need to
proven on the
focus.
record?
I feel it's important at this time to at least give you the advisement pursuant to Special Material 28. It is regarding your decision on whether to testify. I'm not asking you to make that decision, but since we're on the verge of you starting your case and it may impact your opening statement, I wanted to go through the following. Sir, are you aware that you have a constitutional right to testify?
I've been informed.
Are you advised and informed that you also have a constitutional right not to testify?
I'm not advised, I'm informed.
Are you advised and informed that the decision whether to testify is for you to make?
I don't understand the question.
Are you advised and informed that the decision on whether you testify in this trial is for you and you alone to make?
I'm informed. Not advised.
Are you advised and informed, sir, that if you choose not to testify, the jury will be advised that they cannot use that against you? In other words, you have that right not to testify.
I'm informed.
When you make a determination about whether to testify in this trial, I will further be asking you about whether anyone has made any threats or promises to you to influence your decision. I may also briefly go over your educational background. Did you hear me say that?
No, I'll say it again.
At the appropriate time, when we go through this discussion more fully, I will also ask you whether anyone has made any promises to you to influence your decision on whether to testify. Did you hear me say that?
I'm informed.
And then I will also ask you if anyone's made any threats or coerced you in any way in your decision to testify or not,
What's the significance of that?
so that I can make appropriate findings about the voluntariness, intelligence, and your, whether it's knowing, voluntary, and intelligent, your decision to testify.
So whether I give consent.
That's not the legal determination that I make. It is simply something that is your choice. I will honor your right not to testify. Obviously, that's a constitutional right. I will honor your right to testify. That's also a constitutional right. And the jury will be advised one way or the other. There's a jury instruction on that. Did you hear me advise you of all of this?
I'm informed.
All right. Okay, let's bring the jury out then, and we can kind of tidy up the record, and then we'll break for lunch.
Judge, may I remove that exhibit, please?
I think they're right there, so let me just take it.
All right, it's heavy.
Jury already coming out.
I'll just stick
Okay, so go
All
ahead
rise
and sit
for
it
the
back
jury.
down. Thank you. Subject matter jurisdiction still hasn't been proven for the record, Your Honor. Should be proven at some point.
Remind me not to do that twice. Remind me not to do that twice. Okay. That hurt. Oh, that hurt. Thank you, everyone. Please be seated. All right, then I'll turn to the state. Any additional evidence at this time?
The state has no additional evidence, Your Honor. May we make a record as to the exhibits?
Go ahead, please.
Your Honor, we believe that the court has admitted all exhibits that have been offered, with the exception of one prior ruling on Exhibit 6. I don't know if you want me to list them all by number, or there are, it's 1 through 78, 1 through 178, but there are some numbers missing because we chose not to offer those exhibits.
Anything specific as it relates to the most recent testimony?
The most recent testimony, with Detective Casey, we moved 177 and 178 and 175, 150, 151, 88, and 89. I believe those were admitted by the court.
That's my recollection as well, but for the jury, exhibits 150, let me start over, exhibits 88, 89, 150, 151, 177, and 178. If I didn't receive them during the testimony, I'm receiving them now.
And 175, which was the still photo.
Thank you, sorry, I had to scribble on my pad, and 175.
And 13 and 14. Those are the outliers, I apologize.
I believe those were received as well, but if I didn't
Objection, I
state
think
it.
they was already received.
I appreciate that, I just want to be thorough for the record. 13 and 14 were received as well. State have any additional witnesses to call at this time?
No, Your Honor, at this time, the state rests.
All right, thank you. All right, then at this time, we are going to break for the lunch hour. I am going to have everyone come back at 1:30. It's a little bit longer, at least that's what I want to do for the lunch hour today. So all rise for the jury. Thank you, be seated. Mr. Brooks, anything from you at this time, given the state is now rested?
What you mean?
I'm asking you the question. Do you have any requests at this time now that the state has rested?
What request pertaining to what exactly?
I'll ask the question one more time. Do you have any requests to make at this time now that the state has rested?
I don't understand what you mean by that. That's why I'm trying to get clarification.
I'm not going to give you legal advice. I'm simply asking the question. Do you have any requests to make at this time now that the state has rested?
I don't know what I'm supposed to say to that. I don't understand what would that be pertaining to.
I can't give you
don't
legal
know.
advice, sir. I'm just asking the question to make a record. I'll ask you one more time. Do you have any requests to make now that the state has rested?
I don't understand.
All right, the other thing I want to do when the jury comes back out is, you will recall I read instruction 101 at the very end of the preliminary jury instructions that just has to do with opening statements. I will read that with the caveat. It will just say that the defendant will now make his opening statement. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show you, so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statement is not evidence. So I'll read that. I think it's appropriate given that Mr. Brooks deferred his opening statement until the start of his case. With that, we will take our lunch break. It's 12:09. If you could be back here at 1:25 and be ready to go at 1:30 with your opening statement.
I got a question.
Go ahead.
Do I get to present exhibits and stuff like that too and admit them into evidence?
At what point are we talking about? Do you want to use exhibits that have been received during your opening? Is that what you're asking me?
No, I'm saying if I got my own stuff that I want to offer into evidence, which is a question I asked previously.
Do you believe
Yeah.
the state has all of those documents that they might be able to assist with? Or are they new documents?
I don't know what you mean by new documents.
Are they documents from the discovery that you have?
They documents of my filings and stuff like that. I'm sure they have copies of everything that I filed.
I guess without knowing specifically what you're referring to, sir, I did give you the admonition previously that you are prohibited from discussing subject matter jurisdiction during your opening statement. It's not relevant.
I'm not referring to the opening statement. I'm referring to things that I want to offer
Give me
for
an
evidence.
example, please.
I just did. I said I have filings that I want to offer into evidence.
That's too general, sir. I need a specific example so I can answer the question. What are you referring to?
My filings, everything
Which
that I filed,
filing, sir?
every one of them.
Well, they have to be relevant, number one, to the proceedings. Okay, number two, I don't know specifically what you're referring to. You can't offer testimony of yours through an exhibit. That would be hearsay. So you'll have to testify if it's your statement that you're referring to.
I'm not referring to I didn't say anything about testimony. I said
I'm being
filings.
general based on what I've seen thus far. So, are you talking about during your opening statement or during the course of the questioning of the witnesses that you're calling?
Your Honor, with all respect, I just clearly said filings that I filed.
Mr. Brooks, if I understood, I'd answer. I don't understand what you're asking me. You need to be specific.
I've filed a number of documents. I think that's on the
Well, without
record that I
knowing what
filed.
you're referring to, then my answer is no. But again, well, I guess I'll have to wait and see as to when you seek to admit them, whether there's any objection or not, and whether they comply with all of the rules of evidence and the rules of procedure. That's the best I can tell you at this point.
I don't understand what you mean by that. They would only be relevant to obviously the matter. They would
Sir,
be relevant to anything else.
I can't answer that anymore. We're gonna take our lunch break. It's 12:12. We'll see everyone back here at 1:25. We are in recess.
So I'm not allowed to offer anything in the evidence?
For the record, I never said that. We are in recess.
So I'm trying to understand.